So this session is an introduction to IR35, and when I say an introduction, it's fairly detailed. IR35 and the changes that are coming in there are to do with what is actually technically known as the off-payroll working rules. So many people do know them by that name, but they are generally known throughout, sort of sector as IR35. So that's why we're calling them that today. And so just to begin with a little bit of context, the IR35 rules have been around a long time, about 20 years in total, and their purpose really is to ensure that individuals who are working as employees effectively into the terms of their engagement are actually taxed as if they are employees, regardless of the structure they're working through. And that really means regardless whether they are working via an intermediary or loan out, or whether they are directly hired and actually on the payroll. So the IR35 rules were originally introduced in 2000, and they were really designed to make sure that people were being fairly taxed. And for many years, it was actually down to the intermediary. So it was down to the loan out company to assess whether or not somebody was actually engaged as a de facto employee or not. Now, in April 2019, as many of you will know, that changed for the public sector. So engagers such as the BBC, etc., were required to actually assess their contractor population themselves and ascertain whether or not they were genuinely freelance or whether they were really deemed employees for tax purposes. Now, this was deemed to be really successful by HMRC, and as a consequence, the public sector changes were rolled out into the private sector, and they are now being extended in medium and large organisations, and I'll come back to the definition of those criteria in a moment. Are going to be extended from April 2021. Now, as you are probably aware, this has had a bit of a false start. So I suppose one of the silver linings of COVID is that these rules were postponed by a year whilst everyone dealt with something that was frankly a much bigger problem really. But they have been confirmed that they will be coming in. Jessie Norman, who's the Financial Secretary to the Treasury, confirmed this in parliamentary questions 2 or 3 weeks ago. So there really is very little doubt that they will be coming in, and it's not expected that the budget changes on the 3rd of March will impact this. However, obviously, never say never, it's possible, but we've had recent confirmation this won't be the case from senior sources. So in terms of what they actually are, just to remind those who are familiar and just to really introduce those who aren't to these rules, essentially the IR35 rules operate to allocate responsibility for assessing an individual's tax status. They provide a framework for making that assessment, i.e. for looking at an individual contractor on a particular engagement and trying to ascertain whether or not they are genuinely freelance or whether they are a deemed employee. And finally, it allocates responsibility for accounting for tax. So in the cases where a client deems that a person is a deemed employee, they are responsible for deducting the tax, which is here the income tax, national insurance tax and contribution, and paying it across to HMRC. So who they apply to? Now, the off-payroll working rules apply to contractors who are working for a client who are engaged via a loan out. The IR35 rules, technically as they are in their narrow definition, have always applied to people who are directly hired. But these rules coming in, changes that are coming in, are going to impact loan outs. So it is all those contractors who are engaged via an intermediary of some sort. So it's usually a loan out, it can be a partnership, but generally, as we'll know, in the media sector, they are personal service companies known as loan outs. So from April the 6th, who now decides if a contractor is a deemed employee or not? Now, in the public sector, the position remains as it has been since 2017. So that means that clients of all sizes are responsible for applying the IR35 rules and operating payroll if required. Now, in the private sector, there is some division here. So where the client is small, the individual and their personal service company in particular remains responsible for determining whether the IR35 rules apply and operating pay as you earn, PAYE, accordingly. Now, from the 6th of April 2021, you've got medium and large clients in the private sector who are engaging individuals by intermediaries who will be responsible for applying the IR35 rules, and then, as I mentioned earlier, operating PAYE, so deducting the tax if required. And so it's really for that group that these rules are new, and therefore that's where the compliance work will need to be done at the moment. The key question here really is whether you are a contractor or whether you are a private sector client, is where do you sit in the spectrum of size for the purposes of these rules? Are you within these rules if you're a client and actually required to make determination? So to do this, we obviously look at the definition of small. And so small clients are basically those who are not large really for these purposes, or medium or large. And the definition in the Companies Act. And a medium sort of de minimis really is one of 3 tests, which is on the screen now. So a company will be medium or large if 2 or more of the following apply. And that's annual turnover of more than 10.2 million, a balance sheet total of more than 5.1 million, and employees of more than 50. So if you meet 2 of those 3 criteria, then you will be not a small company, so you'll be at least medium and therefore within these rules. Now, there's some detailed rules around this that are in the legislation that really go to address at a sort of a detailed level, granular level, exactly how these rules work in practice. So some of these I've put down here as points to watch, and this is individual companies within a group are only considered small if the parent company is also small, i.e. this is a group test. So you can't have a particular entity for a particular production just because that is small. It won't mean that you're outside these rules. You will look at it on a group level, and at the top co level where the accounts are consolidated, that's where you apply this test. There's also some detailed rules around new companies. So a company is always small in its first financial year. It will continue to be small until it qualifies as medium or large. Equally, if you've got companies that are on the threshold, so perhaps the revenue moves a bit from year to year, as often is the case, depending how many productions a company might be doing, you will only be classified as medium or large if you meet this test for 2 consecutive years. So there is a bit of generosity here, I suppose, a bit of flexibility. They don't want companies having to comply one year and not the other. They're trying to make it something that people can consistently work with from a policy perspective. So if you are a medium or large company, what do you need to do? Or if you are working for a medium or large company, what do you need to be aware of that people are going to do to you in terms of the frequency of assessing your situation? So there's no set standard in the legislation of how often you need to test per se. There is just a requirement that you test, and a level of acceptance, I think, within HMRC that you need to be practical and, to a certain extent, pragmatic about this. So the ground rules are that you should really test immediately before the start of a contract, once you know who the individual is. Ideally, when you've got a long-term contract, by which I mean probably one over 6 months, you test on a regular basis throughout the contract. And then if you are aware as a client that there is a material change in working practices or the contract, then again, we suggest that there is a test run because that might change the outcome of that test. And again, if you are aware there's been a material change in circumstances of your individual, as in your individual contractor, again, there should ideally be a test. And when I talk about a change in circumstances here, I mean really that perhaps if your test has relied on them having business on own account, so other streams of income, and you're happy that they are self-employed on that basis, if those streams have dropped away for any reason, it might be worth re-examining this. Now, clearly in this sector, there's a lot of daily hires, week hires, and you really need to look at this and develop a strategy for how you're going to deal with those. I don't think it's expected that somebody who's taken on a daily contract is hired every single time, but there needs to be a sensible, careful, prudent approach as to how frequently you're going to test and have that really applied consistently through the business.
Ceri, can we just clarify, when you say client, are you referring to the individual who's being hired or the production company?
Sorry, I'm talking about the production company. I'm talking about it from a lawyer's perspective primarily, I suppose. So I'm talking about it from a production company. And also, I suppose, from the contractor's perspective, that would be your client. So that's what I mean. But I mean the engaging entity. I'll call them the engager if it's easier going forward. So that's who would be doing the assessment.
Lovely, thank you.
So in terms of assessing and what you need to look at, this is really based on a body of UK case law. So there's a number of factors that you look at to decide if an individual is being engaged as a deemed employee, and it's really helpful for both contractors and for the engager doing the assessments to be aware of these. You look at mutuality of obligation, i.e. is there an obligation to provide and accept work? That's usually the case if you've got a contract, but obviously the terms of that contract might to some extent influence the degree of the obligation there. You look at personal service. So is the person who's being contracted free to send somebody else in to do a job? And is that unfettered? I mean, do you as an engager have the right to turn away somebody who you don't think is appropriate, or is it just an unfettered right to send in somebody else if for some reason you can't turn up yourself as a contractor to do the work? You look at the degree of control, and that's known as the control framework, and that really is what is there in terms of the actual contract, but also working practices to decide, who is deciding the what, where, and when those services are being provided, whether on-site is determined by the nature of the work, or what controls has the engager got in place to monitor and instruct, really. Then you look at financial risk. So that is the degree to which the contractor is taking on board some financial risk. That's the more risk that they take on board themselves, the more likely they are to be self-employed. They have substantial equipment. If they are, make work that's not deemed to be good enough at their own cost, for example, that will be indicative of self-employment. Next, you look at part and parcel of the organisation. Is that individual really integrated? Have they been at the organisation, perhaps, for example, for some time? Are they part of the management or the strategy of that organisation? Next is told, are you a director of the engager, or do you have a company secretarial role? It's very unlikely in this context, but from HMRC's perspective of case law, that is something that would emphatically make somebody a deemed employee of a company. So the next one is on an account, and that really is looking at whether somebody else has got significant other business and whether they've got other engagements, and if so, how do they have a sort of a regular pattern of other work? From the perspective of the, from the engager and also the contractor, is a requirement, a statutory obligation that the engager uses reasonable care when making this assessment. So that's important that you make it correctly, but also that it's documented that you've made it correctly and the contractor understands and can hold to account for somebody who isn't taking reasonable care. So this is looking at HMRC assessment guidelines, and I will just trot through this because they are available on their website, but it's just really trotting through some of those factors and trying to apply them in real life. So, but somebody is probably self-employed if most of the following are true, and that if they are in business for themselves, responsible for the success or failure of their business and can make a lot of profit. You can decide what work you do, where and when and how. Like, do you do preparatory work in your at home or in an office location of your own? Whether or not you're subcontracting to somebody else to do the work. Is there a pool of staff you can send in? Look at whether or not there's any requirement that work that is unsatisfactory is fixed. And also, do you have to make good of that work at your own cost? So is there a fixed price for the work? Money to buy own business assets, that really covers running costs, whether you're looking at maintenance, whether it's tools, if you've got a sort of a carpentry role or some kind of like making role, or equipment if you're in software or special effects, and also that people work for more than one client is also indicative that they are self-employed and working for themselves. So the assessment then, what do we do in a media context to make the assessment? There are some really helpful media guidelines that the media sector really is hugely lucky to have. They're one of the only sectors, I think, really that has their own tailored or such tailored guidelines. And in particular, there is behind the camera roles, which is really helped by a full list of roles which HMRC view as being potentially capable of being treated as self-employed, and that's known as Appendix 1. And on the slide here, it just shows that certain behind the camera roles are treated here as self-employed, and that HMRC will stand by status determinations that are made relying on Appendix 1. So critical here is the fact that you have a role that's on the Appendix 1 list, that involves the narrative that's on that list, and that also it meets the conditions that are attached to that role title. So there'll be a timing condition, i.e. The role must be for a fixed period, or there will also be a kind of a descriptive criteria, which looks at the functions of that role, the common features of that role. And I've added here on the slide as well COVID roles, because this is obviously a new development in the last year. We have been working with HMRC to try to have added a list a number of COVID, we call them sort of health and safety roles, really. And these are seen as behind the camera, but there's a strong case for them being treated as a mention of the existing health and safety roles. I'm hoping that we will have an update soon on that in terms of positive news, because we have had a very positive reception to that, and we've had been working for, well, since just before Christmas really, to hopefully have these published in time for April. So we'll provide an update, but there are quite a long list of roles there that will hopefully be there, and you will also be able to rely on them as being self-employed, providing you meet the necessary criteria. Now, the other helpful guidance we've got, HMRC, is in front of camera guidance, and that is in respect of actors and other performers. And there's also some that is hopefully going to be released relatively soon in relation to presenters that are being digested really by HMRC at the moment. In terms of already published guidance, there's already a recognition within HMRC that if somebody has a Lorimer letter, which is the second bullet point here on the slide, then they will be accepted as self-employed, provided the role that they are being engaged in respect of is covered by their Lorimer letters. So that means any of you who have one of these letters that you're able to share with your engager, provided that it's within the time period permitted, generally a year period from when you first had it, and provided that it covers the nature of the work covered in that letter, it should be possible to treat you as self-employed. And the rationale behind that is simply that the work patterns of those individuals closely match those of a particular case called the Lorimer case, which you've heard of. It's a long-standing case, and HMRC are happy to confirm that individuals who work in that way should be treated as self-employed. But if you are an engager, you should really be making sure you've got a copy of that letter on your records. Now, the next rule that we look at is the 7-day rule. HMRC permit national insurance contributions to be the only deductions which are made, provided that the contractor is engaged for a period of 7 days or less, and that includes rest days and weekends, which can sometimes trip people up. It's also a requirement of that rule that there's no predetermined arrangements of any kind, whether formal or informal, so written or verbal, for the individual to be engaged frequently or at regular intervals. So that's again something that's important to ascertain as you're doing this. It will determine how, if you have got somebody who's a deemed employee, how much tax you will need to deduct in respect of them. Now, here we've come now to the HMRC's check employment status for tax. This is CEST, the online tool, which is widely known, I know, much improved. It's had recent sort of updates to make it more user-friendly. And the positives about it is that HMRC will accept the decision, provided that the information has been put into the tool, so the answers that you have given to the tool's questions are correct. However, the issue with CEST and the frustrations people have with CEST that you may well have experienced yourselves is that the questions are not industry specific. They don't really take account for the unique way that people often work in the sector. So it means that you often get an answer that you feel is probably not correct, or you get a non-determination, which means that you just don't know. Your case is in a grey area and it hasn't really provided you with a view one way or the other. That would really take you to looking at assessment in respect to that individual. And I'm just going to do a quick slide here, because one of the things we've done at Wiggin is to provide this, basically a means of doing an assessment that incorporates the media guidelines and the CEST test, as well as the bespoke Wiggin advice or legal advice at the end. So it's really just to make this into a smooth electronic compliance process. And I suspect for many of you who've got a large number of contractors, doing it in this way, whether it doesn't obviously need to be the Wiggin tool, but doing it electronically in some way and having a good record of what you've done, and a sort of 6-year record of audit trail should HMRC look at this would be helpful. So moving on then, once you have made your assessment, you send out a status determination statement to your contractor. So I say you as in the engager. So this is the client in the relationship sends to the contractor in the relationship, and also to any agency in the chain, if there is one, a copy of the status determination statement. This is a legal obligation. You must do this for this type of contractor. So when you have somebody who is a loan out. So this is unique. You don't have to do this for direct hires, but you do need to do this for loan outs. And what this will say is it's a risk determination of the contractor's tax status and the reasons for the decision. And it should really state as well the operation of PAYE. You don't have to include that in the statement, but clearly it's helpful to say what the impact of that decision is. So that's to tell somebody, if you are going to be deeming that they are an employee, then you'll be operating PAYE and paying employment taxes to HMRC as necessary. Now, it is the fee payer under the tax rules who must operate PAYE, so make these deductions. So this will be the end user client, i.e. the production company in some cases. If you've got an agency in the chain, it will be the agency that is actually paying the money across to the loan out, the personal service company here. Now, where you are a engager, the end client, and you've made this assessment and you have told the agency in the chain that you have deemed somebody to be an employee and they should be deducting the tax. The way the legislation works is that the liability passes on to the fee payer agency. Now, in practice, there are a number of risk factors to bear in mind. It's not as simple as simply telling your agency, if you are an end user client, an engager, of where the situation is. If you've made that that determination without taking the reasonable care that's required by statute, then again, the employment tax liability, if you've got it wrong and you're incorrectly treating somebody as self-employed, the employment tax liability will come back and sit with you anyway, because you won't have put it to the fee payer. There's also the possibility that you don't notify the next agency in the chain, and there's also a set of statutory dispute resolution policy requirements that you are required to follow if somebody disagrees with your determination. And again, if you haven't complied with those, again, the employment tax will sit back with you. Now, practice, most contracts with payroll agencies, in my experience anyway, will, even if theoretically the liability is with them, there will be some sort of contractual pass back effectively to the production company. It's unlikely to find a payroll agency who will take on that liability for you if you are the engager. So it's certainly not something that you should rely on in terms of passing a way to pass on your tax liability to somebody else in the chain. And I think as well, and there are, well, I know as well, there are other rules that come into play that effectively will achieve the same result. I won't go into the detail of those here. Now, the mechanics of status determination statement. So you need to provide these to workers before you start work. And it must provide the reasons for it. That's all it says in the statute. So ideally, it must have some detail so that your contractor population know that if you are the base assessment, they've got comfort that it's been done properly, and that's a protection for the contractors. So from a contractor perspective, if you're looking at this, you are entitled to receive this statement and also to know, have some understanding of why that determination has been made. As I said, you need to pass down the, make sure there's a full message down to agencies. And again, these status determinations must be repeated regularly if working practices change or new contract entered into. Now, this is on to once you've had that determination as a contractor, what are your rights, or what can you do? Now, engagers are required to put in what's called client-led status disagreement process. And that's just some protections really to deal with disagreements that come to you from your contractors. So as a contractor, you're entitled to disagree with the determination, and you are entitled to challenge it. So you register your disagreement or dispute with it. And once you've done that, your client must give you a response within 45 days. So it's expected that the engager revisits their decision and actually make some sort of assessment as to whether or not that was correct, or whether, and they can confirm the original decision and provide reasons for that, or if they want to amend that decision, they need to provide a new status determination statement saying, actually, we agree, we revisited this, we agree you're not, say, an employee, but actually we found sound reason for treating you and taxing you as a self-employed contractor. Now, obviously, from a contractor's perspective, it's helpful when you disagree to provide reasons for that disagreement and to actually put your case forward. That's really your moment to input into the process. At least you have the statutory right to input at that moment, should you wish. So that it's really important that you don't just disagree, that you actually perhaps do it in writing with some clear rationale in order to maximise your chances of having a decision overturned if you think it's unfair. This is interaction with employment law, and this is basically just a point really just to say that whilst the employment tax is different from the employment law, you deem somebody's status separately for employment law purposes. Obviously, there is a degree of similarity in terms of the test that you use. In employment law, there is additional status of worker. So you have employed, a worker status, and then a self-employed person. And so it's also, when you're looking at your position, the tax rules, is always worth considering where you stand from an employment law perspective too. Deemed employee status determination for tax purposes will not automatically trigger additional employment rights, but whichever side of the fence you are, so to speak, whether you're the engager or the contractor, it's certainly worth considering. So here are some points going forward, just to make sure that people are clear, I suppose, what you should be doing now in the run-up until April. So for contractors, it's important to understand the implications for you if you have a loan out and what this might mean, and just look at who you are providing your services to and why they are, and so whether these new rules will apply to you. We recommend, from your perspective, that you communicate with those engaging with you at an early stage. So, for example, when Wiggin that I mentioned earlier, we have it as a best practice that contractors are consulted at the start of the assessment to have any information that is pertinent to them fed in approach, rather than just having an engager do it in isolation. It's also in the interest of contractors clearly to provide accurate information in respect of what they are feeding into that process. But equally, it's important for them to be communicated with and provided with themselves accurate information as to what the assessment process is, and how it's going to be managed, and also the dispute procedures and what they have available to them if they want to disagree. From production company perspective, this is the engager. You really need to identify which of your contractor population fall within these new rules, so which are coming to you sort of via loan out company, and then do an assessment of their actual position, their employment tax status, but also a budgetary assessment in terms of the impact of that. It's also important to review and update your template contracts to make sure that you have the right to deduct if should you need it, but also that both parties are working together to make sure there's education flow so the assessments remain current and accurate. It's usually helpful to update policies as well, the onboarding policies and the dispute policies, so you've got the right policies and procedures, you've got this compliance framework in place. And finally, one of the biggest issues really is just the communication between the two sides, between contractors and the engagers. So that comes to training your personnel, so they're making accurate assessments, but also messing them in a way that minimises any disagreement or any sort of sense of injustice. And that obviously includes clear communications with contractors. But most of all, we would kind of encourage people really just to address it. I mean, this is a problem. I think there's been some hope especially whilst people have been dealing with larger problems with COVID, that perhaps there'll be a delay in bringing in these rules, or perhaps, you know, they won't be too closely looked at with so much going on. But we are certainly hearing from HMRC that this is an area that is live, it is happening, and we are expecting there to be, you know, some compliance follow-up once there's been, you know, sufficient time for people to bed in these policies. So how can we help? As I said, we've done appendix 1 work, we're continuing with that, we're continuing to add roles to that. We are also just advising companies really at every stage of this process. We are able to help you with put the IR35 compliance framework in place, whether that is in terms of policies and procedures, and just update those so you are compliant with the new rules. But also we can help with the assessments, and probably, I guess, our biggest sort of contribution there. We can do hard copy, etc., but the biggest contribution there is the IR35 manager platform that automates it from beginning to end. Because the one advantage, frankly, of having a year of lockdown, had time to develop a platform to do this smoothly and quickly. And finally, it's relationship management. I think, you know, we can help message, we can help train, and we're very happy to do that. So that's the end of my talk. I've got some website links to HMRC's websites that are attached to the slides. I won't show the slides up on screen now for any time because there's quite a few of them, but there's lots of support from HMRC here. There's lots of webinars run by HMRC as well as, you know, the generic ones, but they are all there in terms of international impact and things. So there's a good list of guidelines there, and that's it for me really. So if you've got any questions, very happy to answer them.
Brilliant, thank you. Yes, lots of questions have come in as we were going through that. So I'm going to try and start with some just clarifications. Does inclusion in Appendix 1 overrule any assessment that you would do?
It doesn't overrule it. There's not, HMRC not recognise a pecking order when it comes to their guidelines. So it's not one thing trumps the other, but you are absolutely entitled to rely on it. So if you meet the narrative and if you meet the conditions that are attached to that particular role title, then you can treat somebody as being self-employed. You don't need to do more in terms of assessment. That's enough. It provides the industry essentially with a shortcut way of assessing people. So you have this Appendix 1. There's also a sort of Appendix 2, which is roles like Appendix 1 roles in substance, but perhaps aren't actually on Appendix 1. So when we're advising people, we have pure Appendix 1, but we will also look at roles that are very analogous to that, which perhaps aren't included on Appendix 1, because frankly, when we were drafting it and working with HMRC, we stopped some point and publish it. You couldn't continue putting roles on it. You've got to draw lines. You can't, and you know, there's development of roles all the time. But there is this sense of things that are very similar substantively to Appendix 1. You could take a view on, but I probably would recommend you seek advice before doing that. If you're just doing this yourself, I would keep it quite simple and just look at Appendix 1 and the criteria there. But make sure you do look at the criteria, because that's the piece that people go slightly wrong on sometimes.
Okay. Can the client declare the employment status decision on the contract rather than in a separate letter?
Yes, I would think so. There's no reason to communicate to the contractor, but frankly, if it's in a document that somebody has signed, I think that's pretty convincingly communicated. So yes, I think perhaps the only difficulty with putting it in a contract is if that changed over the term of that contract. So say it's a longer term contract, so 9 months, 12 months, even 18 months, that's where you're at with it, and you've got a determination there. You would be expected to review that. I think you wouldn't, if something had changed, or just regularly anyway. We tend to probably say, as I said during the talk, that you at least sort of check in and make sure that working practice are the same. So that I guess the risk of doing it in the contract is that you might then have to override it outside the contract, which is a little bit messy. So we don't tend to do that, but you can do that, but just being aware that you need to message outside if necessary.
Okay, great. And then quite a few questions around penciling bookings and then cancelling them. How does pencil bookings work in terms of mutuality of obligation? If you're booking somebody and then cancelling them, but you pay them some sort of cancellation fee, but there was no actual work done, does that still fall under the IR35 regs?
Ooh, I think in terms of penciling in, I mean, that's kind of a rostering point. So I think in terms of mutuality of obligation, my based on a kind of a take on that, I wouldn't expect it to be contractually binding. So if you've penciled somebody in, but you've not confirmed, and they're not, you're not obliged to turn up, basically, if you are the contractor on that day. If that's not the understanding you have, there'd be no I don't think you necessarily got a contract. So I think you might be all right in terms of mutuality of obligation, but maybe you're not paying them then. So I think it's in the rostering sense, I think you should be okay with them, presumably when you have. So what was the second point you had said, Kim, in terms of the
so yeah, there was one
situation?
about if you've penciled somebody and then cancelled. If you've contracted somebody but then the work is cancelled or the shoot is postponed, but you pay them a cancellation fee, so they haven't actually done any work for you, but you have given them a payment.
I think that suggests that you do have a contract and you have met mutuality of obligation. So I think that would be subject to these rules, because you appear to be compensating them for not giving them the work, which suggests that you have an obligation to give them the work. So I think you would have to make an assessment there, and then you pay tax accordingly. I think if you're looking at these sort of quite informal arrangements, if you've got lots of daily contracts that are coming and going, or weekly contracts that come and going, you're not actually expected to assess each time. Perhaps you can take a sort of a 3-monthly view or something, and if it's freelance, perhaps just do one assessment and treat that person the same for the ad hoc engagements over the next couple of months or 3 months or something, would be my feel. I don't think you expect it reasonably. We need to have a good case with HMRC for saying that we're not going to literally assess every time we pencil somebody in. We're just going to assess them once and then let it sort of run on those terms for a couple of months, and then revisit it depending how much they've worked for you perhaps over the last couple of months and are going to work for you over the next couple of months, and do an assessment on that basis.
Okay. Okay, let's move on. The size of the engager. So is it the entity that's engaging the employee, or would it class as the whole company? So SVPs and parent companies, if it's come from somewhere like that.
Yeah, it's the whole group. So it's not simply the engaging entity. You will look at it in the round. So you will look at it at top co level, the parent.
Okay. What would be the recommended minimum level of detail on an SDS that would show reasonable care?
Yeah, I think to evidence reasonable care, well, first of all, you've got to have identified your contractor population correctly and that they're within the rules. But in terms of what you're telling the contractor, I think you've got to probably just explain what you're doing. So what you're assessing them under these rules and why, because you're bound to by statute, and then obviously give them the outcome, so whether they are self-employed or employed in your view under these rules. But I do think it's not that you have to tell them in detail why, but I think some detail is helpful to minimise disputes, just so the person who's receiving the message can understand why. They might not agree with the result, but they can at least see that you've reached that and you've given it some thought, and in particular haven't done some sort of mass assessment. I think that can sometimes be an issue if you're the contractor and you feel that your personal position or your personal contract hasn't been properly considered. But you do also really need to tell them the impact for them, because there's no point in saying you're employed if you then tell them what that means in terms of what you are going to do when you're paying them. You need to tell them that you're deducting tax and national insurance contributions. They shouldn't really be finding out whether their pay packet net of tax, because you can almost guarantee that you will be hearing from them. The amount of detail is something of a judgment call, and it might depend on the individual and the complexity of the case. Obviously, if you're self-employed, you're messaging somebody that they're self-employed, that's generally a position that all parties are happy with. So as long as, from an engager perspective, you've you're comfortable with that, you probably need to keep it quite, there's no need to go into lots of detail as to why you think they're self-employed, but you do need to have this audit trail potential HMRC. So some of it is messaging. It's more really about actually making sure that your process internally engage it, that actually has reasonable care baked into it and it's consistently applied. Because what you don't want is to have people who are engaged on very similar terms with different determinations. You don't want that in terms of, it doesn't look very convincing. It doesn't sound like it's worked in terms of an assessment and it's a fair and impartial assessment, but you obviously have contractor population sort of disputes being very highly likely if they are being treated differently from their contemporaries, their peers.
If you've done the assessment and it comes out they should be on PAYE, are there further obligations on the production company then towards pension or holiday pay and all of those kind of extra benefits?
Yes, potentially, and that was really where I was going to in terms of the actual the employment law aspects and why these we looked at sort of hand in hand with the employment tax. So because they have these three different roles categories, I suppose, the employed, the worker and the self-employed, the employment rights and the employment law are different for each of those. If you have somebody who would be employed for tax purposes, you're likely to be looking at somebody who's at least a worker or an employee under employment law. So you therefore get holiday rights, auto enrolments or pension rights, etc. So an employee has more rights than a worker, but a worker does have some basic rights that one will need to be budgeted for, but also obviously managed and allocated and hopefully messaged as well, because generally when you become when you switch from employed to employed as a contractor, your take home drops a little bit, and one of the silver linings is that you have got some of these additional employment benefits often.
Do you want to go through just the definitions of things like sole trader, freelancer, Schedule D, loan outs and direct hire companies, what the differences between those are and what the differences in managing IR35 for those might be?
Yeah, sure. I mean, there's obviously a lot of terms that are banned around, and in all honesty, they're sort of different terms for very similar things, really. A direct hire, when somebody talks about a direct hire, they typically mean they are directly hiring the individual. So you are engaging with a contractor directly as a person, so not through their company, but as a person. And that's when you start talking about Schedule D contracts as well. Schedule D is a bit of a throwback from old tax law, where and it used to be on a tax and they have to put that in. So that's why it's called. It's not really around. It's not really a thing anymore. People do call it that, which is why you might have come across it as a track, or you might use it, I suppose, as an engager, just because it's what it's always been called historically. So yes, the sole traders, direct hires really are the same thing as a Schedule D. In terms of loan outs are personal service companies, and the definition of a loan out is really the thrust of it is a personal service company that somebody who is the contractor has a stake in, or people who are sort of friends and family, close relations to that contractor have stake in. So that is where you have the indirect hires. So you're basically hiring services, but not directly from a person. You're hiring a company to provide those services. And so really what these rules are doing is trying to just identify when it's a little bit of a sham to all intents and purposes, is that you are really just hiring that individual directly. So you just look at it as if you didn't have that service company in the way. You just look at that relationship between that individual and the engager and assess on that basis, which is what you would do with a direct hire.
What is the process for umbrella companies?
It's basically it's a company really where the individual who is providing the service, or the pool of individuals providing the services, don't really have a personal stake in the company. They are just amongst a number of employees, and you contract that company to provide sort of a package of services, say, not linked so much to that one individual. Is the umbrella company has been, I mean, it's been pushed to the limit in terms of tax planning, I think. So you've had, it's not a bad thing in itself. I think it has sometimes negative connotations in the press because people have pushed the envelope in terms of offshore and trying to do more planning around it. But in its most vanilla sense, where you've just got an umbrella company with individuals that it employs providing service, where you've got that umbrella company contracting with the engagers, the production company, for a set of services provided by different people, that is fine. As an engager, you might want to check that is what's happening and put contractual protections in place, but it's not a problem per se. It's when that umbrella company is artificial, as it were, and perhaps rather than just having services provided by a company to you as a production company, you're very looking at services provided by a particular individual within that company. And then you start to muddy the waters in terms of the tax analysis, and you have to be more on your guard as a production company with those engagements to make sure that you aren't, again, engaging with somebody more directly. You're not creating an employee relationship in a sense. So umbrella companies do need to be certainly checked. If you are engaging people via an umbrella companies, I would certainly have a look at that arrangement and the nature of that arrangement and do some analysis based on the facts.